বলছে?
ক্যামেরাটা ব্যাক হয়।
ঠিকই তো করলাম। হ্যাঁ ঠিকই তো করলাম। সাজিয়ে দিয়েছে। শুরু হয়ে গেছে। সরে যাবে, সামনে থেকে সরে যাবে, সামনে থেকে সরে যাবে। পিছিয়ে গেছো? ঠিক আছে ঠিক আছে, তেমন তেমন। ওটা ঠিক হচ্ছে না তো, বারবার করছে, হচ্ছে না তো। ঠিক করলাম তো, নয়নদা এসে করলে হলো না তো। ঠিক করলাম তো।
This is a case where Pierre Desai is an investigative journalist. And by the evidence that was submitted in the trial court, we have provided that there has been a rise in insurgent activities due to the same. Now, in the trial found to be guilty under the charges of the Unlawful Activities Prevention Act. But after that, Priya Desai went to recourse on the appellate judiciary body in the High Court. And the High Court overturned the decision by stating and taking in amicus curiae briefs and additional evidence given by the respondents, which decided that they overturned the decision favoring it in favor of Priya Desai. Now we are here in front of you to provide an appeal as to we have believed that there has been an error on the part of High Court in interpreting national security and freedom of press side by side, along with the error in procedure of law they have done by accepting additional evidence which was not of substantial justice in the present case.
Before all that, just satisfy this court that why do you consider a journalist to be a terrorist?
Sir, we have not claimed her activities under the provisions of terrorism in the UAPA. We have said that her activities are unlawful and that she has abetted and cited her actions of...
For every unlawful activity you take resort to the UAPA? Every unlawful activity that is being carried on in this country, you take resort to the UAPA?
No sir, we do not. But in the present case, her actions align with the provisions that have been specially curated for such actions under the Unlawful Preventions Act, which is why
That's precisely the question. That in this country, which I guess on last count it continued to call itself a democracy, here you have an investigative journalist who's being branded a terrorist by your government.
Right, sir. As I have contended, we are not claiming her to be a terrorist. We are saying that even if there was no intent on her part to breach national security, her actions have justified that she has done so. Because due to that, the evidence that she has submitted during the trial itself shows that there was a rise in insurgent messages in exchange, in encrypted messages.
How can you be so sure that it was because of her reporting that the insurgent activities suddenly rose? It would have been a result of a number of other things.
Sir, the state is very relevant on protecting its national. So we always keep a clear check on insurgent activities all the time.
Absolutely. That's precisely the point, counsel.
Your Lordship,
That
yes.
despite not keeping a clear check, ordinary reporting by one individual has suddenly given rise to so much insurgent activity. Then what is the magnitude of your clear check?
Your Lordship, this has not been the first time that due to the interference of media, certain sensitive publications or information has influenced the activities of terrorism. If we look back at the Mumbai terrorism attack, back then due to wrongful media coverage, the terrorists did intercept some information that helped them in curbing their activities, which was a threat to the national security, and in this instance the same has occurred as well. We are not contending that she did all of it with clear intent, but her actions...
So you have enough evidence to establish that causal linkage between her reporting a particular incident and the concomitant rise of insurgent activities. So you have very clear proof, because this court is not going to accept conjectures. This is the highest court of law in this country, and this court is not going to accept conjectures.
Right, sir?
Very good. Do one thing. You present your court case in your own way. After conclusion of your argument, if we have got any question, we will ask you some questions.
Sir, I will be dealing with issue 1 and issue 2 of this case. We have 4 legal issues in it. I will be dealing with the first and second one. My co-counsel will be dealing with the third and fourth issue. So the first issue that we are dealing with is whether this appeal is maintainable under Article 136 that is guaranteed by the Indian Constitution. Most humbly submitted to this honorable court that this present appeal is maintainable under Article 136. For this, I would like to shortly debrief on the scope of Article 136, which gives a special discretionary power to this court to consider any SLP filed under it, and it has stated some grounds on the basis of which this has been decided. So, in its course, Article 136 is a delineated avenue from the conventional nature in which appeals are heard in the appellate mechanism. Now, I'd like to cite the case of Koneha Ahmed vs. State of Kerala, which you can refer to in page 15, paragraph 1.2 of our memorial, where it states that in elucidating the contours of the Supreme Court's authority in scrutinizing judgments based on the...
Is that page number?
Sir, page 15, paragraph 1.2.
Page 15, paragraph?
1.2.
Yes, 1.2.
Right, sir. Sir, in this case, it has been clearly elaborated that the parameters governing the maintenance of an SLP require 3 grounds. That is a substantial question of injustice or miscarriage of justice, or where there has been error in the procedure and application of law, which swiftly brings me to my second point, that there has been an error in the application of law, which is why this appeal is maintainable under Article 136.
What is the error?
Sir, the High Court's decision to overturn the lower court's upholding of Priya Desai's charges was based on two key things. That is the additional evidence that they accepted under Section 391 of the Criminal Procedure of Code, and the amicus curiae briefs that they took into consideration while determining their judgment. Now, the amicus curiae briefs that were taken up by them consisted only of the civil organizations that deal with the freedom of press. In nowhere in the consideration was there a security expert that could enlighten us about the role of national security against freedom of press. They could have easily taken somebody from the National Investigating Agency or any other security forces that they deemed fit for this. For example, I would like to cite a writer from the center who is a professor of a strategic professor at the Center of Policy Research. He writes extensively on issues regarding national security. At the same time, the press must avoid sensationalization when reporting on sensitive military or intelligent matters that could jeopardize lives or operations, which has happened in the current case, my lord. My lord, the state conducts various military operations, defense operations that can not always be given out to the information to the public. Some of it has to be kept under wraps. For this, even there is a separate legislation called the Official Secret Act that has to be avoided by the government officials as well. So that is the right of the state to withhold certain information if it believes that such information goes out to the public would jeopardize operations, which is
Secret.
right, sir. Which has happened in this case because the information that has been publicized by Ms. Desai has caused a derailment of a lot of the ongoing operations that the state was functioning upon.
Is there a law, is there a legislation that can override a fundamental right to freedom of speech and expression?
Sir, actually this would be extensively dealt by my co-counsel because it is one of the legal issues that we have in hand. However, I would like to cite that
At a time when you did not have public order as a defense to Article 91A. So don't cite archaic cases. It's
Sir, but
a pre-First Amendment
but the
case.
scope of public order was decided upon in this case, where it was stated that public order and public safety are allied matters. But we have to see that
This is a 1951 case. We are here in 2024.
2021 Pegasus judgment.
Exactly.
You can't use national security as a basis for some sort of spectre for all.
Sir, I understand that it is an archaic case, but the spirit of the case remains the same when we are talking about public order and public security against freedom of press. That is why Article 19 subclause 2 also exists, so that freedom of speech and expression is guaranteed, but it doesn't overreach the limitations that it puts the state
Article
in.
19.2 requires the state to impose reasonable restrictions to satisfy the scope of the reasonableness of your restrictions. You can't simply stop anybody. In that case, we shall not be a democracy anymore.
Sir, if you would allow me, I would like you to refer to the MOOT proposition, paragraph 5, line 20. This has been an evidence submitted by the defense themselves.
Paragraph 5 of which?
Sir, paragraph 5, line 20.
Read out.
Sir, it states that additionally the defense produced documented instances from the past where similar government operations, once made public, led to policy reforms and increased public awareness without compromising national security. And this has been submitted by the defense itself. So it's not like the state is always out for dissent against them. We do take dissent that is critical, that is necessary for policy reformation, and we do take it into consideration. But in the present case, there has been instance where insurgent activities did raise. If we did not have a concern against the writing of Ms. Desai, we would not have applied the charges that have been applied against her. We have taken into consideration that it is the right of journalists to dissent the state, and it is the role of the government to hold itself accountable when it is needed to do so. However, that is not the matter in the present.
Aware of this doctrine called the doctrine of proportionality.
Yes, sir.
Now, doctrine of proportionality demands that if there is a lesser restrictive means, then you resort to insurgent activities as a result of her writing, couldn't you have chosen some other means than putting her to jail?
Sir, but then if we allow this leeway to journalists, but there is no threshold of where they would stop in their dissent, and if that
No,
is
fair enough. You don't allow the leeway. But is putting a journalist into jail your only recourse?
Sir, if we look at the recent amendments into UAPA, I would like to cite a case that has been very recent about this. It is, just a moment.
Has some You can justify the abridgment of fundamental right by citing the UAPA.
Sir, if you just allow me, if you look at the case of Gurvinder Singh versus State of Punjab, which is a very recent case from 2024, there the rule has been established that bail must be rejected as a rule if after hearing the public prosecutor and after perusing the final report or case diary, the court arrives at the conclusion that there are reasonable grounds for believing that the accusation of a prima facie true, which was the instance in the trial court itself. The trial court understood that the accusations that were being put forward for Ms. Desai were very valid and there was actual concern behind restricting her writing. There, again, I am reciting it, that the state does not believe in stifling the voice of journalists, but it is very reasonable to do so if it puts the state in jeopardy itself.
Please enlighten us as to why this court will overlook the evidence which has been adduced by the trial court and which according to the trial court has been proved, but which has been not, according to the High Court, has not been, because we are getting an appeal against a criminal appeal, no? It's a criminal appeal.
Yes.
This appeal has not been preferred challenging the order of quash. So there are some evidence on record. Why this court will believe those evidence at this stage?
Right, sir. That is exactly what I would have presented in my second issue. That is why the additional evidence should not have been admissible in the court in the first instance. Because the additional evidence that the respondents submitted from their side, similar reports had already been submitted in the trial court itself, where the trial court had gone through it and decided that despite the evidence that they provided, it was not enough to establish that her writing or her actions were beyond the threshold of putting national security into danger. That was the trial court's decision itself. Now when we see what the High Court had done, it took into acceptance the additional evidence that they had provided. But we do not find any substantive effect to that additional evidence that was provided, because these reports were already of similar nature available at the trial court itself. And she had due time to provide this information at the trial court as well. There was no need for it to be given as an additional evidence at the appellate mechanism itself. We believe that the client was just trying to mend her case and fill in the gaps that she could not have done so at the trial stage itself. Further, as I had stated, the amicus curiae briefs that the court took into consideration did not include any state security personnel that could have given an opinion about themselves. So we believe there has been an imbalance of the same for it. That is all that I would have covered in my...
So are you alleging bias with the High Court?
Yes, sir. We are alleging that there has been a gross injustice of law, and that is why this present appeal has been put forward to the court.
So is the High Court required to consult government agencies in its choice of amicus curiae briefs? Is there any precedent?
Sir, when we look at third-party briefs, I believe that each of the parties to that has to be given a consideration. That is also in the course of natural
then it's not
justice.
a third party. If each of the contesting parties had to be given a consideration,
when
then how is it a
when third-party briefs are being allowed, then you have to give similar balance to each of the aspects of it.
No, but it's not about being allowed. The High Court is asking for amicus curiae briefs. So it's not necessary that the High Court will ask one of the contesting parties to submit an amicus curiae brief.
We are not.
Then it's no longer an amicus curiae
We are not
brief.
stating that they should have asked us for a third-party brief, but if they decided that third-party briefs were to be taken into consideration, then there has been a bias in only considering civil rights organizations into it. At least one person from a state security machinery should also have been included.
But you are
into
already
it.
representing the state.
Right?
Now the High Court is asking for a third party brief, and the High Court in its wisdom has chosen a few civil liberties organizations to submit their amicus curiae briefs. Then where is the High Court
Sir,
wrong?
we believe that was not required because if you look at the trial stage itself, in the trial stage...
No, but you cannot dictate terms to the High Court.
Sir, that is why we believe
Whether
that
it is required or not is the High Court's prerogative to decide, right?
Sir, that is why we believe that there has been an bias in the High Court's judgment of it, which is why we have come to the appellate
What we are
mechanism
on
for redressal.
exactly, that by inviting the views of the amicus, whether any miscarriage of justice according to has been occurred.
That is the contention of our side, sir, that a error has occurred on our side and we believe so. So we need a review on the same. So if you are well satisfied, then I'd call my co-counsel for dealing with the third and fourth issue of the case.
Allowed.
Much obliged, Your Lordship.
Yes, yes. Present.
Your Lordship, the counsel seeks permission to address the bench as Your Lordship.
Come closer to mic. Adjust your mic. Yes.
The counsel seeks permission to address the bench as Your Lordships.
Sure. Please proceed.
Much obliged, Your Lordship. Your Lordship, I'll be dealing with issue 3, 4 and the prayer. Your Lordship, my first issue at hand, that is issue 3, is whether the High Court has erred in in elevating the freedom of press over national security under Article 19. Your Lordship, as we know that the Indian Constitution guarantees us the freedom of free speech and expression under Article 19, Clause 1, Subclause A. However, this is not an absolute right and it is subject to certain reasonable restrictions that has been laid down under Article 19, Clause 2. And thus, the right to publish, publish information even in the context of journalism cannot exempt an individual from the liability of the consequences of their action, of their publication. Your Lordship,
Counsel, which restriction under 19.2 are you invoking?
there are certain reasonable restrictions and one of the main grounds of imposing such reasonable restrictions are to maintain the sovereignty and integrity of India and in the interest of national security. And both of these are getting fulfilled in this case, Your Lordship. And
Counsel, what do you mean by sovereignty and integrity of India? Is there any legal definition of sovereignty and integrity of India? Any precedent?
Your Lordship, as of this moment, I apologize for not being aware of any precedent on this matter, but the sovereignty and integrity of India means that...
so commonsensically, how do you define sovereignty and integrity of India?
Give me one moment, Your Lordship. The supreme power, Your Lordship, the supreme power and sovereignty that India holds.
The supreme power that India holds.
In its territory.
In your definition, does India stand for the government of India?
I'm sorry, Your Lordship, could you
In your definition of sovereignty of India, does India stand for the government of India? Are you trying to say that the sovereignty of India can only be safeguarded by the government of India yielding a supreme power? Because from the looks of it, what you are trying to do is, in the interest of security of state, in the interest of sovereignty and integrity of India, you are, it appears to this court, imposing absolutely unreasonable, draconian and disproportionate restrictions on a journalist's freedom of speech and expression. If democracy happens to be the part of basic structure of the constitution, how are you doing this? And how are you justifying this, counsel?
Your Lordship, these restrictions are not absolutely vague or just mere restrictions, and we are not just accusing a journalist of being terrorist. We are just saying that whatever her acts were, the acts of publishing informations that have caused several security concerns throughout the country, and several strategies had to be altered because of that publication, Your Lordship.
Do you have a concrete proof to say that it was because of her acts that national security was jeopardized?
Indeed, Your Lordship, during the trial at the Sessions Court, we have submitted enough evidence that provided the concrete evidence that...
But the High Court had overturned all those evidences.
That is correct, Your Lordship, and that's why we
So
are here.
are you asking us to believe in the Sessions Court and disbelieve in the High Court?
No, Your Lordship, I am asking the Honorable Apex Court to look at the evidences that has been provided, a documented evidence that was also submitted at the trial court. It contained communications were intercepted among hostile entities, which they directly referenced information that was revealed in Desai's article. And that creates a direct link, and also forensic experts also have testified and claimed, Your Honor, that there is a direct link, and there's been an increase in encrypted messages after Desai's publishing of that article that
But
leaked
couldn't it have
sensitive
been
information.
coincidental? Couldn't it have been coincidental that
I think the facts also say it's only suggestive. It's
Exactly.
It's not established by your own, by the case provided itself.
it's just suggested? So
Give
how are you
me-
so sure? When you are abridging somebody's fundamental rights, how are you so sure that this must have happened?
Give me one moment to
Facts
prepare.
have been that there's some other plan that is there, and that's why there's an increase in communication amongst unlawful elements, and that it just coincides with the publishing of the article. There could be so many things that coincide that we are not aware of with the publishing of the article.
Give me one moment to prepare my answer, Your Lordship.
I believe it would be proper to look to the evidence as has been recorded by the learned trial court, both oral and documentary. And on perusal of those evidence, you have to justify yourself that from the evidence of the prosecution witnesses as well as from the exhibits, it would reveal that on account of the publication of the article by the accused, there was insurgency and there was direct chain. And the court should not ignore the linkage between the insurgent activities or for invoking UAPA, especially when UAPA has not yet been declared ultra-virus. Still it is intra-virus. So your argument should be that it should at the appellate stage, when the Supreme Court will decide an appeal, even on the point of law, it cannot overlook the evidence which has been brought before the learned trial court.
Your Lordship, I understand your perspective. However, I humbly disagree that instances cannot be coincidence. And if we also look at the proposition, para 5, it says, a particular line, it says, a high-ranking official from Indian Intelligence Service.
Page number.
I do not have the page number of the proposition, Your Lordship. That is the para 5.
So that's precisely the point. Your intelligence service is claiming that there has been an increase. So you
Yes.
are representing the state. It's your intelligence service. So they are all on your side. Just look at the counter narrative. In the same paragraph, it says that yes. So the defense argues, and the defense also invokes the evidence given by a digital security expert, which clearly says that there was no direct evidence. So it's one person's version against another one's. So why should I believe your version and disbelieve theirs?
Because, Your Lordship, a digital forensic expert or a high-ranking official, they are well competent to understand what causes a security breach, since
but
they
how do you
are
define
always on the
competence?
field.
This statement is going against you. The statement of the high-ranking digital security expert arguing that there was no direct evidence linking SI's article to the alleged increase in insurgent communications.
No, this one is a digital security expert. Paragraph 5, this one is a digital, this is the defense's version. They're claiming this, line number 6.
Okay, they've read this one.
Shall I read it out to you, Your
No,
Lordship?
we've got it. We've got it.
So, may I move to my next point, or do you have any more questions on this point, Your Lordship?
No, come to the next point.
Your Lordship, my next ground is the High Court's over-reliance on the amicus curiae briefs. We understand that amicus curiae briefs do provide very insightful and valuable informations. However, they are not they cannot be replaced of any core evidentiary element in a particular case. And I am not saying this. The courts are, Your Lordship. I would like to mention a case of State of Punjab versus Davidar Pal Singh Ballar. In this case, Your Lordship, the Indian Supreme Court re-established and highlighted the role of an amicus curiae is advisory in nature. The court must base its judgment on established facts, verified evidence and law, and not external arguments submitted by the amicus.
Is Devendra Singh Bhullar's case still the valid law? Or has it not been overruled in a subsequent case?
As per my knowledge, Your Lordship, it has not been overruled, and it is
Just revise your knowledge, counsel. It has been overruled.
I have another case law, Your Lordship, that is, it's an international case law, is the Mohawk Indus INC versus the Carpenter case law. The US Supreme Court in this case recognized that while the third party briefs can influence judicial making, they cannot override factual evidence. And we have, Your Lordship, provided factual evidences at the trial court.
Which they have as well, counsel. So it's one party's factual evidence versus another party's factual evidence. So if the High Court has in its wisdom decided to also ask for amicus curiae briefs, and the High Court is well within the law to ask for it, how can you stop them?
Your Lordship, we are not stopping them. However, we believe that amicus curiae briefs, taking insights from amicus curiae who lacked the necessary expertise in security law and counter-terrorism operation, I wonder how reliable is that, Your Lordship, when it comes to important and sensitive topics like...
If the High Court assesses the reliability, if the High Court does not find amicus curiae brief to be reliable, the High Court will not accept it.
That is what I humbly disagree with, Your Lordship, and we humbly disagree with, because the security personnel, their lives have been at stake because of this publication, and this publication of Priya Desai, the article's publication, revealed sensitive information that have jeopardized the national security. And thus we believe that security personnel who are working in the field 24/7 for the security of the state to provide us security, we should rely on their opinions as well. We should look at their opinions as well, rather than amicus curiae, who I believe they are not expertised in.
Counsel, the High Court is not disregarding their opinions. You are the ones who are representing them.
Yes,
so the High Court has already heard their opinions, because you are representing the Union of India. So naturally, their opinions are all very well articulated. You are eminent lawyers here. If the High Court is asking for some additional views and some additional perspectives, what is your problem with it?
Your Lordship, the main aim, we believe, and we contend, of providing the amicus curiae briefs was mainly because to shift the issue from national security causes to human rights violation, which the respondents have claimed that the operation have caused human rights violation, but they couldn't provide any concrete proof on that. These are just mere claims of them, and to divert the issue from national security, they have come up with the amicus curiae briefs.
Intention on the part of the High Court to say that the High Court is kind of getting influenced by adding a few more layers of amicus curiae to the petitioners?
No, Your Lordship, it's not the High Court we are talking about. We are talking about the respondents there, and whatever there.
The amicus curiae are not related to them. The amicus curiae are third parties.
Exactly, Your Lordship, but third party briefs cannot. They can influence, but they cannot be considered main evidences in a decision making in a particular case. That is what I was trying to highlight.
Leave that to the High Court. The High Court is competent to decide on that.
That is why we are here, Your Lordship, because we disagree with that, and we believe the High Court over-reliance might be fatal when it comes to national security in future cases as well.
Ultimately, what we have perceived, that according to you, the amicus argued in such a manner, it persuaded the High Court to think in another perspective. without considering the materials on record. I believe it would be your contention, and there miscarriage of justice occurred.
Yes, Your Lordship.
Now tell us one thing. In the event, the amicus placed the case in such a fashion that it is really not a threat to the security of the country, or on the contrary, it postulates the correct provision of the Article 19. So where is the bar in making such, taking such submission on behalf, which has been advanced on behalf of the amicus? There is no bar, I believe. It is the High Court who decides, rightly or wrongly, that we will adjudicate. But where is the difficulty in accepting the contention, or at least not accepting, but in not considering the contention as raised by the amicus?
Your Lordship, the respondents have claimed that the amicus curiae, with the amicus curiae briefs, it claims that the possible human rights violation that has happened. And as I mentioned earlier, that it was done, we contend that it was done with the intention of diverting the main issue, that was the cause of security breach, from security breach to the possible human rights violation, which they believe have done, but they haven't provided any concrete evidences, Your Lordship.
Is it the practice in the High Court, which is an appellate court, that too in a criminal matter, the amicus will adduce evidence? Where is the scope? There is no scope in the Evidence Act, so far our knowledge goes.
Your Lordship, I didn't understand your question. Could you please inform me?
Amicus will make an endeavor to reach a correct decision so that the court can give its judgment. So how the amicus can adduce evidence? In a criminal trial, evidence are adduced before the learned trial court only. There is no scope of adducing evidence in a criminal appeal, because an appeal court deals with the evidence, both oral and documentary. So how amicus can adduce evidence in the High Court? It is unheard of.
Your Lordship, the amicus curiae was taken into consideration when the additional evidence by Desai's team was submitted.
Very good. Come to the next point.
Your Lordship, my next point is, even though freedom of press is important, but that is not at the cost of national security. And we have seen even past instances as well where the publishing of sensitive information have caused several security breaches. For instance, if we look at the Mumbai attack 2008, we will see that the real-time reporting have caused several security breaches, Your Lordship. That again jeopardize the national security. Again, if I mention...
Counsel, this is a constitutional court, so argue on grounds of law.
Indeed, Your Lordship. Your Lordship, I would like to mention a case in this context, that is the Ex-Armaments Protection Forum versus Union of India. Again, this is a very recent case of 2013. The Supreme Court upheld the suppression of information when it jeopardized national security, emphasizing that the press cannot claim absolute freedom when it compromises security.
Counsel, that recent case is an 11-year-old case. A more recent case, the Pegasus case, has categorically said, and the Supreme Court of India has categorically said, that you can't use the national security as a bogey every time.
We are not using the topic of national security as a blanket justification, Your Lordship, because we have also allowed, like, a lot of the articles that are being published by the journalists, they criticize the governmental operations. We have no issue with that, Your Lordship. That is a fundamental right.
Now allowing articles critical of the government to be published? I think we still have a constitution.
I apologize for my choice of words, Your Lordship. So that is not the case here, Your Lordship, because the information that was leaked in Desai's article that have caused security concerns, and many security strategies had to be compromised, had to be altered because of that. That is why we have raised this concern, and that is why we are before this apex court seeking for justice, Your Lordship.
Very good. Any other point, ma'am?
Yes, Your Lordship. I still have my issue 4, but before that, I would like to mention some international legal standards in this context. Article 19 of the International Covenant on Civil and Political Rights protects the right to freedom of expression, but
you don't need to argue this, counsel. As in, we have a constitution, we are satisfied with it.
Your Lordship, I am...
You can move to your next point.
Indeed, Your Lordship. Your Lordship, my next issue is whether the provision of the Unlawful Activities Prevention Act are being misused and arbitrarily applied. We humbly submit that all the charges that has been brought against Ms. Desai are just and rightfully applied. Your Lordship, journalists do have the right to cover secret operations and post and publish articles on sensitive informations. However, there are certain ethical considerations that should be kept in mind, which is this case Priya Desai did not, and especially in cases which endanger...
Fair enough, but ethical considerations are not the domain of this court.
But Your Lordship...
Is there any legal breach that she has done?
Yes, Your Lordship.
So which section has she violated?
We have charged her, the state has charged her under section 2 clause O and section 13 clause B
section
of the
definition
UAP.
section, counsel. You can't charge anybody under a definition section.
Absolutely, Your Lordship. There's section 2 clause O that covers what unlawful activities are, and section 13 clause B that talks about, that criminalizes any kind of unlawful activity that jeopardizes the national security of the state.
So tell me something, counsel. Which unlawful activity has she committed?
She has
definitions.
revealed and leaked informations, Your Lordship.
No, read from the definition.
Indeed,
Which
Your
unlawful
Lordship.
activity has she committed under the definition of the UAP?
Give me one moment, Your Lordship.
Sure.
Section 13B says, punishment for unlawful activities, section B, clause B, advocates, abets, advises or incites the commissioner of any unlawful activity shall be punishable with imprisonment.
That's all right. An unlawful activity. The question that we are asking you is, what is that unlawful activity that she has committed?
She has incited violence, Your Lordship.
Incited violence.
Yes.
Now, is incitement to violence an unlawful activity under 2O?
Yes, Your Lordship.
Define.
Your Lordship, what we are trying to say in this context
No,
is,
you read the definition.
section 2 subclause O states, unlawful activity in relation to an individual or association means any action taken by any such individual or association, whether by committing an act or by words either spoken or written, or by signs or by visible representation or otherwise. This is what we are trying to say, Your Lordship. Her words have
where is the
incited
unlawful activity?
violence.
So where is the unlawful activity?
The leaking of sensitive information, Your Lordship, that is unlawful because that jeopardizes the national security of the state.
Okay. Is there any other point that you have to make?
Yes, Your Lordship, I do.
Yes, please.
Your Lordship, as we know that she has revealed sensitive informations, and revealing those information creates a clear breach of national security, and when it comes to intentions, the Unlawful Activities Prevention Act clearly emphasizes that this statute is not concerned about one's intentions, rather the consequences of one's act. So whatever her intentions was, be it malafide or be it bona fide, it doesn't matter because it is immaterial in this matter. As whatever her intention was, she has already caused the security breach, Your Lordship. And that brings me to a case law. That is the Muhammad Ayub Sheikh versus Union of India. Your Lordship, in this case, it was held that the prosecution need not prove intent to harm national security. It is sufficient to prove that the act had the potential to endanger public safety and aid unlawful activities. Another case law is the state of Kerala versus Ranif. Your Lordship, in this case, the court emphasized while intent is relevant factor in some cases, it is not always necessary under the Unlawful Activities Prevention Act. Another important case law I would like to mention.
Right. That is understood. Is there any other argument?
Your Lordship, my last point is the test of proportionality. we are aware that the test of proportionality was not established in the Kedarnath Singh case. It was established in another case, that is the Omkar case. However, we are referring to the Kedarnath Singh case because of the essence of that case that it holds.
But Kedarnath Singh is under consideration.
Yes, Your Lordship.
Counsel, proportionality was adequately discussed in the electoral bonds case. Proportionality was adequately discussed in a number of other cases in the last 2 or 3 years by this court. So why are you asking us to go back to Kedarnath Singh, a 1962 case?
Your Lordship, Kedarnath Singh case has similar facts that we have in this case. That was related to sedition laws. However, this is not related to
Counsel,
sedition
Kedarnath
laws.
Singh was a constitutional challenge to sedition.
That is correct, Your Lordship.
But doctrine of proportionality as a principle was discussed in Puttaswamy, and this court is bound by it. It's a larger bench.
We are taking the essence that was ruled in that case, Your Lordship.
No,
that
so
said that
you want us to disregard Puttaswamy, you want us to disregard electoral bonds, and you want us to follow a case which itself is under a lot of suspicion and whatever.
No, Your Lordship, we are not.
Then why are you not referring to the cases, the seminal cases that are talking about proportionality? Why are you sticking to Kedarnath Singh?
Alright, Your Lordship, then I will move to another case. That is the Anand Teltumde versus State of Maharashtra. In this case, while hearing Teltumde's bail plea, the court rejected the bail.
But does the court in Teltumde discuss proportionality? Is it a case on proportionality? Because your argument is on proportionality. You are trying to argue that the punishment that was meted out to Priya was proportional. So in that context, you refer to Anuradha Bhasin, you refer to Puttaswamy, you refer to electoral bonds. Why are you referring to a case where proportionality is not even an issue?
Your Lordship, I am taking the essence from that case. What I am trying to establish here is
But the Supreme Court has
threshold.
categorically laid down the 4 parameters that, on the basis of which you use proportionality.
Your
Why do you, beating around the bush, counsel?
Your Lordship, in this case, in Teltumde's case, the bail, the test was applied in the context of bail plea, and that is why I was citing this case.
What
Your
is
Lordship.
proportionality? What are the prongs of proportionality?
It's the necessity or whether the action taken by the government or the state authority was necessary to its goal, to meet its goal, especially when it curtails freedom of speech or any fundamental
Number 2,
rights.
there are 4 prongs to proportionality, counsel.
We are referring to this one here, Your Lordship.
So you can't cherry pick. If you have to refer to proportionality, you refer to all prongs of proportionality. You can't cherry pick among the different prongs.
Your Lordship, what we are trying to establish is that the threshold.
Proportionality, the most important element of the doctrine of proportionality is this, that you have to choose the least restrictive measure. Now, do you say that incarceration is the least restrictive measure?
In this case, it is the most just measure, I believe, Your Lordship, because it has caused security breaches, and if we let this go, then what is the guarantee that many more cases will not endanger the national security again?
You could have, so are you trying to suggest that other than arresting her, there was nothing else that you could have done?
Your Lordship, that article was already published, and that article that could be accessed by any foreign adversaries and insurgent groups, that has already caused us several security breaches, Your Lordship. Then how can we let this person go without filing a case,
So
without charging
is your
her?
government now starting to impose pre-censorship? Is it suggesting that it should now start to impose pre-censorship? Because an article which is already published and you have a problem with it, so now would you like to control an article before it is published? Is that your scheme now?
No, Your Lordship. What
Thank
we are trying to refer here is that her publishing of that article have caused security breaches, and we cannot go back in time and or get any other remedy that can fix this possibly, other than charging her. This will create an example that one should not be publishing, and one should maintain at least this amount of rationality and practice rationality while publishing and writing about sensitive content. content.
Very good. Thank you.
May I move to the prayer, Your Lordship?
Yes.
Wherefore, in the light of the issue raised, argument advanced, and authorities cited, it is humbly requested that this honourable court may be pleased to adjudge and declare: Number 1, the instant special leave petition is maintainable in the instant case as its present condition and shall be accepted. Number 2, to set aside the High Court's decision in elevating freedom of press over national security. Number 3, to review High Court's decision in accepting additional evidence and determine its necessity and role in the present matter. Number 4, to uphold the learned Session Court's original decision of finding the accused guilty of charges under the Prevention of Unlawful Activities Act 1967 and pass any such order that it deems fit in the interest of justice, equity and good conscience. It was an honour presenting this case before the Honourable Court, Your Lordship.
Thank you.
Yes.
May it please the court. Much obliged. Greetings to the honorable bench. I am the first speaker assisted by my co-counsel representing the respondent Priya Desai in the matter of the state of Indira versus Priya Desai before this distinguished bench. Now, the counsel would like to seek the permission to address the whole bench collectively as your lordship. Much obliged. Now, with due permission of the court, the counsel would like to proceed with the statement of jurisdiction. Much obliged to your lordship. The jurisdiction of this honorable court is invoked under Article 136 of the Constitution, which confers the authority to hear an appeal from any decision of the land except the ones under the laws of armed forces. And as this petition is against the decision of High Court, I humbly submit that this honorable court has the requisite jurisdiction to hear and decide this case. Now, if the court is well versed with the factual matrix of this case, I would like to proceed with the issue number 1.
Yes.
Okay. So, now with due permission, as the first issue will be addressed by me and the other two issues will be addressed by my co-counsel. Now, the first issue at hand regarding this case is whether the special leave petition made by the petitioner, the state of Indira, is maintainable in the apex court or not. Your lordship, the counsel humbly submits that the case should not be maintained in this apex court. The article
Counsel, 136 is a discretionary remedy. So this court is exercising its discretion to hear this case. So I think this point is infructuous.
Your lordship, what the counsel...
You can't direct this court to exercise its discretion in the way that you want to.
Your lordship, what we are trying to submit is that the court has the requisite jurisdiction and they can decide, and they has the discretionary power to accept the SLP or they can also deny the SLP.
So we are exercising our discretion.
Yes, but there are certain case laws in that the Supreme Court itself has restricted itself and said there are certain circumstances when the court should accept the SLP or the deny the SLP. Not every person who is coming to Supreme Court and just going for Article 136 and saying that I am the aggrieved party.
Counsel, are you trying to suggest that a litigant will dictate the Supreme Court which case to accept and which case not to?
No.
So this court is accepting this case because we think that this is a shocking case where, as a result of a reporting, the lives of so many people, so many hundreds of people have been put into jeopardy. It's a case that is shocking our conscience. So we are accepting this case. So now you can't tell us that there are previous precedents which say that you can or you cannot.
But your lordship, what we are trying to present is that there are certain grounds on basis of which the Supreme Court should not accept this case. Like the High Court has itself given the very much detailed judgment in this case. They has also examined the various evidences, also taken the guidance from amicus curiae, also overturned the previous judgment of Supreme Court.
Probably I have understood your contention that both the trial court and the High Court have dealt with the statement, dealt with the facts and the laws. Is it not the duty of the Supreme Court to deal with those laws in order to assess whether the factual aspects based on evidence have been rightly assessed by the learned by the Honorable High Court.
Yes, Your
So
Lordship.
which is why a provision of SLP has been incorporated in the Constitution of India. So why SLP will not be maintainable?
Your Lordship, we are saying that any person who thinks that I am the aggrieved party just can't go to Supreme Court and say that I am the aggrieved party and
Counsel, it's ultimately upon the Supreme Court to accept or reject. The Supreme Court is accepting it, then where is your problem?
Your Lordship, we know that this is the discretionary power of the Supreme Court, and we are just suggesting that there are certain
No,
grounds.
we are not accepting your suggestion.
Supreme Court is not hearing a conquering judgment. A judgment of conviction has been passed by the trial court, which has been overturned by the High Court. So a duty is cast upon the Supreme Court to assess whether High Court is justified or the Sessions Court is justified.
No,
It's
Your
not
Lord-
that the Sessions Court is always wrong. There are many instances that the judgment of civil judge junior division is being affirmed in the Honorable Supreme Court. Though it has been affirmed, not affirmed, rather overturned or set aside by the district court and the High Court.
Your Lordship, what we're trying to ascertain, we just can't say that as a council that what the Supreme Court should do. Obviously, we
Come to the
So
next point.
let's summarize. Every party, every litigant has a right to come to Supreme Court.
Yes, they
Every
can.
it is discretion of the Supreme Court to admit the appeal or not to admit.
Your Lordship.
Today the appeal is admitted. That is not a discussion point any longer. We have moved on from there. Now you tell us why we should not grant them orders.
Your Lordship, in that case, there are two issues left that will be handled by my co-counsel. Then I would like to call upon my co-counsel.
Very good.
Much obliged to Your Lordship.
Yes, sir.
Much obliged to your lordship. May it please the court. Much obliged to your lordship. Now, if your lordship permits, I would like to proceed with the next issue. So the second issue at hand is whether national security can be used as a blanket or tool for government to curtail the fundamental rights of freedom of speech and expression and freedom of press under Article 19 of the Constitution of India. In the humble opinion...
Ma'am, before you start, I'm sorry to disturb you. Usually I do not disturb. You have come before, what is the predicament on your part to raise this issue at the time of the lodging of the FIR? Even why you have not come before the Honorable High Court for quashing of the FIR? Why you are raising these points when several evidence have already come into record? Is it according to you, is it a correct time to assess those theoretical problems when the evidence are already on record? What prevented you to choose to approach the appropriate forum under section 482?
Your Lordship, I would like to clear some points is that the first case that was filed on the respondent was at the Sessions Court, which was done by the state itself, and in the Sessions Court after the trial, the respondent was convicted, but then the respondent appealed to the High Court, and in the High Court, the respondent was acquitted of all charges. And here again in Supreme Court, before the Honorable Court, the respondent hasn't come. The petitioner has come for appeal against the High Court's order of acquittal of the. So there is no FIR against the respondent currently. So that is the reason why there is no quashing of FIR.
No, probably you didn't get my point. What I'm on, that when you are raising the applicability of the law in the perspective of the constitutional provision, you could have come before the Honorable High Court for quashing of the FIR. Even you ought to have come before the High Court at the time of or immediately after consideration of charge. What I am on, that rightly or wrongly, the charges of UAPA have been proved on the basis of the evidence as recorded by the London Trial Court. Admittedly, High Court has not accepted the proposition of the Social Sessions Court. It says that from the materials on record, the evidence the charges have not been proved. You are defending the High Court judgment, no? So my question is, when you are raising these points in this specially petition appeal, what prevented you to raise this point earlier?
Your Lordship, actually we are bound by the proposition itself, so we cannot go beyond it. So because this is a moot court problem and we are bound by the proposition, we cannot go away from that and raise our own points on our own grounds. That's the reason why.
Very good.
So now if your Lordship permits, I would like to continue. So the second issue at hand is whether national security can be used as a blanket or tool for government to curtail the fundamental rights to freedom of speech and expression and freedom of press under Article 19 of the Constitution of India. In the humble opinion of the
Is there something called a freedom of press?
Well, exactly, Your Lordship, I'm coming to the point that freedom of press is not explicitly mentioned in under Article 19, but in the case of Indian Express newspaper versus Union of India, the Supreme Court observed the expression freedom of press has not been used in Article 19, but it comprehends within Article 19A. So even though it is not expressly used, through interpretation, judicial interpretation, it's been included under Article 19A. So it does come within its ambit.
Now, counsel, tell me something. The party that you are representing, Priya, she has written something which in all likelihood has led to some tension, some trouble. Now, whether it amounts to the trouble that they are claiming or not, that's a different question. We are not getting there right away. Is it not the prerogative of the government to impose reasonable restrictions on her rights?
Well, Your Lordship, it is indeed.
Is your freedom of press or freedom of speech an unrestricted, unfettered right?
No, Your Lordship, the freedom of speech, expression, press, everything is rightfully restricted under Article 19, Clause 2, that is providing the freedom itself, but the restriction is based on certain points, that is national sovereignty, integrity, if national security is harmed. But the investigative report that was published by the respondent did not cause harm to any of these. So restrictions can be done, but that should be reasonable in nature. Here the restriction was not reasonable in nature, hence in this particular situation.
Is there any test, counsel, to determine reasonableness?
Exactly. Your Lordship, there is a reasonability test to define there is a test called reasonability test to check if the restrictions are reasonable or not. According to this test, the reasonableness demands proper balancing. The phrase.
What is the precedent that you're relying on?
Well, Your Lordship, this is actually. We have actually taken the test as itself, like the test we have.
No, test as itself cannot be there.
Yes, sir.
The test must have been created by some precedent or backed by some precedent. What is the precedent that you're relying on? Because it's a very important thing. You are telling this court that reasonableness, as in the restrictions that they have imposed, are unreasonable. So naturally, this court is asking you, what do you mean by reasonableness?
Well,
so that
Your
cannot be a
Lordship,
commonsensical answer.
Well, Your
It has to be backed by
Lordship,
evidence.
for that, I beg your pardon for not having the case itself right now, but even Article 19 Clause 2 that provides the clause for restriction, it also provides the fact that the restriction should be reasonable.
Absolutely.
So,
and this is exactly what we are asking you. So how do you define reasonable restrictions?
Your Lordship, reasonable restriction will be a fact when the thing is actually happening. So if national security is actually being damaged, then restriction can be implicated.
So you are trying to suggest that there cannot be any preemptive restrictions imposed on speech. In that case, counsel, how would you justify pre-censorship of cinema? If there can't be any preemptive restrictions on speech, then how is cinema pre-censored?
Well, Your Lordship, the pre-censorship of the cinema is actually not based on residuary things. It is actually based on things that actually happen. Let's say that there is, for example...
it's not happened because the cinema is not out.
Your Lordship, the fact that cinema is not out, but what is the probable content that could be out?
So based on probable content you censor?
Yes, Your Lordship. And
Okay.
indeed, based on probable content, freedom
So
of...
here, based on the probable implications of her writing, the government has censored her. So where is the problem?
No, Your Lordship, Your Lordship, when cinema is censored, that is, there are certain things, like, for example, you cannot show live killing on television. So, probably there are certain things that actually happened because of that is the reason why these restrictions are taken place to prohibit those things. But it's not like there nothing has happened, but suddenly we are bringing restrictions. Here in this case, the
So
investigation...
here also the government is erring on the side of caution. The government feels that as a result of writings like these, the national security situation has been compromised. And there is a propensity that writings like this will further compromise the national security.
Well, Your Lordship, if the government thinks that writings like this could compromise, then they should have brought some previous... Well, any law can be only prospective, especially criminal and penalizing law. They cannot be retrospective in nature. So either this law has to exist previously for this to apply in this case,
No, you have an UAPA.
That is the next issue, Your Lordship, that UAPA is not covering the scope of journalistic activities. UAPA does not, journalistic activities does not come within the scope of UAPA.
No, so you tell me something, as in just now you said that a law cannot be retrospective, a penal law cannot be retrospective. Fair enough, accept it. The question is, which penal law is being used retrospectively here?
I'm not saying that penal law is being retrospectively. Just like you mentioned that there can be restrictions, or just because they have thought in their head that might happen. So in that case, they
That's
can...
not retrospective.
Your Lordship, in that case, if they have actually brought previous regulations that these things are not to be published, then only they can restrict that person or...
You cannot expect, you cannot expect the government to bring in regulations to the extent of micromanaging your publication. All the tests that the Supreme Court has evolved so far to determine what constitutes a public order related reasonable restriction are all premised on the fact that if your publication or if your speech, your expression has an element of a proximate linkage to an ongoing, to an ensuing public order disturbance, that's good enough, that's sufficient for the state to impose reasonable restrictions.
Well,
so they have imposed reasonable restrictions on the premise that your client's journalistic writings, for whatever it was worth, has most likely led to national security troubles.
But the contention of the respondent is that it hasn't led to any of these.
That's a different contention. Your argument right now was that there was no regulation, there was no set of prohibitions, and therefore now for the government to do any such thing is a retrospective application of a penal law.
No, Your Lordship, that wasn't the contention. The fact that I say that the regulations, as you said that TV regulations are made, on movie regulations were made. So these regulations are previously made. So the censorships it's not like once the movie is released, then we are saying that the movie did not follow the censorship.
Yes, but the Supreme Court has also time and again said that cinema is the only category of speech which will be subject to pre-censorship. For everything else, the censorship will have to be post facto.
Well, then it's self-explanatory. Why?
So now they have imposed post facto censorship. Then where is your problem?
May you repeat, Your Lordship?
So they have imposed post facto censorship. So after your client has written this, they feel that it has led to national security troubles, therefore they are penalizing her. Then where is the problem?
The problem is that it is not leading to national security. They cannot falsely penalize someone. That is the contention, that they are penalizing someone based on
So your
grounds that are
problem
false.
is not with the penalizing. Let's get your arguments right. So your problem is not with regards to their capacity to penalize you. So you have to concede that point.
Yes, Your Lordship.
Because right now you have argued that you had a problem even with their capacity to penalize. That's not the case then.
No, Your Lordship.
Your contention is that she has been specifically falsely penalized.
Yes, Your Lordship.
So just stick to that.
Yes, Your Lordship. So here in this case, the respondent has been falsely penalized. Her freedom of speech, and we know that press and media works as the fourth pillar of democracy, and time and again this helps to check the democracy, to criticize the government rightfully. Because if there is no proper criticism of the government will go on doing whatever they...
So is it also within the press's domain to carry on a concurrent reporting of an anti-terror operation?
Anti-terror operation, Your Lordship, I would like to...
The reference that they were trying to cite, that when the Mumbai terrorist attacks were happening and there was an anti-terrorism operation going on, you had television reporters also covering that anti-terrorism operations, which had aggravated the situation. Now, are you trying to suggest that it is within the domain of the press and your freedom of speech and expression to allow the press to carry on writing anything about national security issues without the government having any authority to impose any form of restrictions on them?
Absolutely not, Your Lordship. I would like to say that that particular case, Mumbai terror attack case, and this case are two separate cases. They are not coinciding with each other.
Why are they separate?
Because that was a reporting going on. That was, the terror attack was going on, media was present at the scene, they were reporting, that's a different thing. They were doing...
So here the terrorists are attacking based on your media report. So
no, Your Lordship, that is just an accusation. It is just falsely accusation made on the respondent to
but they have
forcefully
produced
bring
evidence.
her. No, Your Lordship, there is no such concrete evidence produced in that regard.
But they are citing digital forensic experts and everybody else.
Even though the digital forensic experts also just claimed. There is a difference between claimed and affirmed.
No, absolutely.
So they are just claiming.
But on issues of National Security Council, don't you think that it is more prudent that we err on the side of caution?
Yes, Your Lordship, indeed. But the cautions should be based on some incidents that are taking place. We need to refer to para 2 of the MOOT proposition, where it is said that the respondents expose meticulously detail the intricacies of a covert operations conducted by Indira's security forces in a disputed territory, shedding light on actions that sparked widespread debate on ethical boundaries and legal... Here, what happened is that these Indian security forces that were in name of covert operations, they were actually damaging civilians' lives. It was also proved under para 10.
So as we understand, there are two angles to your story. There is one angle where you are alleging some human rights violations. But while you are doing it, there is also another fact that you are also telling them that, well, the security forces are doing X operation at Y site. Now, the court is not concerned about the human rights violation aspects. Of course, you are the press, you have a right to expose human rights violations. But why pinpoint on the specific sites where such operations are being conducted? Because that is what is creating the national security compromises.
Well, the human rights violations are taking...
You can even blur the visuals, you can even beep the names and report the same story.
Your Lordship, the human rights violations are done by these people only, by
Absolutely.
the government itself.
So that is exactly what we are asking you. So if you are to write a story about a human rights violation, do you need to pinpoint at which site, which operation, which commander, and all of that?
Your Lordship, it is
because that is what is leading to the terrorists to whatever.
I'll
Lordship.
rephrase what my lord is saying. Just to be able to bring home the point that there is human rights violation, do you need to sacrifice national security for that?
No,
or can you bring out the allegation of human rights violation and report on the human rights violation without compromising the security angle?
Your Lordship, the fact is that the security, the leak of security, these are all just accusations. There is no...
There is substantial statements made that there has been a surge in conversations and cryptic conversations with coinciding with this.
But
isn't that... How much can you link it? Is the government going to wait for an attack to happen to be able to give a causal effect?
But Your Lordship, there is no direct evidence that is proving that the surge in those...
What kind of evidence can there be? Will there be a simultaneous terrorist attack or something?
No,
they
Your
have
Lordship.
got evidence saying that there is a surge of communication happening coinciding with this. What more can they give?
Your Lordship, the fact that these that was produced saying that these hostile entities are attacking, these were produced in a sealed dossier that just perpetrated. I mean, this wasn't exactly the case. Purportedly containing communications. So we don't know that it's actually communications also. Here they are actually trying to bring...
No, so what is given in the sealed cover, are you saying they gave entirely different documents in the sealed cover than what they have alleged to have been given? The
No,
court
Your
did not
Lordship,
see what
but-
was given in the sealed
No,
cover.
Your Lordship, but the sealed cover was given by the... We need to test the authenticity of those
The
documents.
sealed cover, it has been given in a sealed cover because it is confidential information and the court has taken that into cognizance. So
Yes, Your Lordship,
there's a-
but-
that is why it has not been served upon you. If it was to be served upon you, then what? We wouldn't be sitting here discussing national security.
No, Your Lordship, but the same sealed dossier that was provided in this sessions court was also provided, the record of sessions.
So that's precisely the point. Now, if we evaluate it and find out that there is some causal link, now do you still want to argue that this court cannot take actions against your client?
Your Lordship, if there is any link, then obviously the court has right to take actions, but there is no link.
Now,
But-
how are you so sure that there is no link?
Because the respondent has never released such secret information. These are just accusations by the if
No,
the
but there is-
respondent has never
but the secret information has been submitted to this court in a sealed cover.
secret information is not submitted, probably, Your Lordship. They are saying that the prosecution presented a serial purportedly containing communication incepted from hostile entities.
Yes.
So they are saying
So those communications are categorically pointing towards the fact that all these insurgencies had increased after the publication of this particular, journalistic writing. That seal cover contains such details.
a digital forensic expert who claimed that the surge in encrypted messages among insiders spiked immediately of the articles.
No, fine. Even if we disregard all their versions, there is some evidence which draw a causal link between the writing and the terrorist operations, the surge in the terrorist operations.
Your Lordship, how
Ma'am,
come?
what prevented you to go through the Evidence Act, which deals with the direct evidence and the circumstantial evidence? According to you, the evidence which has been laid before the Sessions Court are the direct evidence or the circumstantial evidence?
They are the
And-
circumstantial evidences.
Then what are the law prevailing in the country relating to the acceptance of the circumstantial evidence?
I beg your pardon, Your Lordship. I'm not well versed with those facts.
Yes. In a case based on circumstantial evidence, the prosecution is liable to prove that the entire chain is complete. Why don't you argue in that fashion? Since the case before the learned trial court or the Sessions Court is based on purely on circumstantial evidence, and the prosecution has miserably failed to prove the charges because there are various breakage of chain. So far, the circumstantial evidence as adduced show that the allegation as that the charge as framed against the accused is not been proved. I request you that whenever you argue before a case of court, you definitely go through the cases, the reported decisions, the precedents, what my lord has stated. But at the same time, I request you, both the prosecution lawyers and the defense lawyers, to go through the act itself also.
I really appreciate your advice, Your Lordship. Thank you so much.
Any other point you want to argue?
There is another issue, that the last issue is that whether the application of UAPA to journalistic activities is within the scope of the Act. Now first we need to understand what is the scope of UAPA Act. UAPA is an act to protect the nation's national security, integrity and sovereignty, and there are majorly two types
Council, read the statement of objects and reasons to the UAPA. Read the statement of objects and reasons.
Okay, Your Lordship. The objective of the Act is provided in the Act itself, which state that it is an Act to provide for the more effective prevention of certain unlawful activities of individuals and associations, and for dealing with terrorist activities
Right.
and for matters concerned therewith.
So the purpose of this Act is to prevent terrorist activities, effective prevention of terrorist activities. So to prevent terrorist activities effectively, the government is empowered to adopt any means. Then
Please,
where is it?
Reduce the fan speed.
Then where is it in the UAPA which says that journalists cannot be, accused under the UAPA?
Well, Your Lordship, there is nowhere in the UAPA that it is said that journalistic activities, because unlawful activities can come within the ambit.
No. Understand this. To effectively prevent terrorist activities, the UAPA can be invoked. We're not saying that journalists are terrorists. All that the government is arguing here is that by invoking the UAPA on such journalistic writings, and some of these journalistic writings are also voyeuristic in nature, terrorist activities are being prevented effectively.
Well, Your Lordship, the contention is that we need to understand what is terrorist activities under UAPA, because only those activities can be prevented. So, terrorist activities are defined under section 15 of the UAPA, and it says that whoever does any act which intend or threaten or likely to threaten the unity, integrity, security, economic security or sovereignty of India, or within intent to strike terror or likely to strike terror in the people or any section of the people in India or in any foreign country by using bombs, dynamites or other explosive substances or
Also, there's
inflammable.
an or in between.
Yes, Your
Right?
Lordship, there is an
The or is a disjunctive or. So you can't use it in the conjunctive sense. So again, read the section very slowly. Just read the first part.
whoever does any act with intent to threaten or likely to threaten the unity, integrity, security, including economic security or sovereignty of India, or
Yes.
with intent to strike
Okay, stop
terror.
there, stop there. Then there is a or. So now with intent, your client has written a piece which has threatened the security of state.
Your Lordship, there was no intent. The intent of the respondent was to protect the civilians' human rights, which was being violated. That was in
And
public
to protect the
interest.
civilians' human rights, she has leaked very, very crucial pieces of
Again, Your
information that has aided the terrorists.
Again, Your Lordship, these leak of evidence were just grave accusations by the petitioner, but it wasn't actually proven, so it cannot be taken into consideration. It is not, it is just accusations on the respondent. She hasn't done anything like that. The fact that the government is trying to deny
Under the UAPA, upon whom is the burden of proof?
So the burden of proof is on the person that is accused.
Then
Then it is proven in front of the Honorable High Court, that was already proven that the respondent has not done any such acts. She hasn't threatened the national security of the country of Indira.
Why are you jumping steps, counsel? It was already proven before the Honorable Trial Court that your client had actually compromised national security.
Well, Your Lordship, then before the Honorable Trial Court, it was completely based on the circumstantial evidences, and circumstantial evidences are not the exact evidence. That should be direct evidence should be provided, and the reason that there are no direct evidence, so the High Court rejected those.
No, so by your own admission, the burden of proof is not on the prosecution, it's on the accused.
So that burden of proof is actually fulfilled before the Honorable High Court, because the respondent was able to prove her innocence and get out of the charges.
so according to you, the onus is upon the prosecution to prove that you are guilty. So according to you, the onus are now upon the prosecution to prove that you are guilty.
No, Your Lordship, the question over here is that.
No, according to you, you have discharged your burden to prove your innocence.
No, Your Lordship.
No.
No, Your Lordship, according
Try to understand my question.
Yes, Your
Before
Lordship.
the learned trial court, in a case under UAPA Act, you said that the defense has been able to prove that he or she is innocent. So the onus is upon the prosecution to prove that you are
Yes,
not
Your
innocent.
Lordship.
That
Yes,
I
Your
intend to
Lordship.
say.
Yes, Your Lordship. So since they failed to produce any direct evidence.
Don't say yes to yes or no to no. Try to understand our question.
Sir, Your Lordship, I would like to justify the statement. The fact that they failed to produce any direct evidences before the trial court and again before the High Court, the respondent indeed proved her innocence. Her innocence was proved. So when they are coming, they are filing this appeal before the Honorable Supreme Court. It is their liability to prove that through direct evidences that the respondent is guilty of those charges.
What would be your argument, ma'am, that when a court deals with when a court, even a Supreme Court deals with a case of an acquittal, what would be the course of action a court of law will take while dealing with a case of law of acquittal?
I didn't get your question, Your Lordship.
We are hearing a case, we are hearing an appeal challenging an order of acquittal. Are you armed with any decision or any proposition of law? What would be the role of a court while dealing with a case of acquittal?
I beg your pardon, Your Lordship.
You ought to have come with that. That would be a very good defense. Absolutely. The law is settled in this regard that when a case, when a court of law is dealing with a case of acquittal, a presumption of innocence is strict with the accused. So the court must be very cautious to overturn that judgment.
Again, I beg your pardon, Your Lordship. I'm sorry for my.
No, it's all right.
So is there any other argument that you have?
No, Your Lordship. Now,
Come to your prayer then.
Conclude your argument.
proceed with the prayer.
Yes.
Yes.
Wherefore, in views of the facts stated, issues raised, argument advanced, and authorities cited, it is most humbly prayed before this Honorable Apex Court that it may be graciously pleased to, first, dismiss the SLP filed by the petitioner and uphold the judgment by the Honorable High Court of Indira in favor of the respondent. Secondly, declare that the respondent's action as a journalist are protected under the constitutional right to freedom of speech and expression, specifically under Article 19, and that her investigative reporting serves the public interest. Thirdly, hold that the application of the Unlawful Activities Prevention Act in this case is an overreach and that the respondent's publication of the article does not constitute a threat to national security. Fourthly, reaffirm the importance of press freedom in a democratic society and declare that journalists should not be penalized for exposing matters of public interest, including potential human rights violation. And lastly, pass any other order or orders and discretion or guidelines as this Honorable Apex Court deems fit, proper, and necessary in the interest of justice, equity, and good conscience. And for this act of kindness, the respondent, as in duty bound, shall forever pray. Much obliged to your Lordship.
Thank you.
Sorry? Yes. Give us a second. Give us a second.
What have to do with this speaker 1 and speaker 2?
স্যার এইটা হচ্ছে
Speaker 1 is
ওভারঅল
the first person speaking.
ওভারঅল এটা হচ্ছে অ্যাপেলেন্টের স্পিকার 1 আর স্পিকার 2, এটা আবার হচ্ছে রেসপন্ডেন্টের ওভারঅল, রেসপন্ডেন্ট স্পিকার। হ্যাঁ, এটা হচ্ছে আউট অফ 50
Out of 150, they will be assessed.
প্রবাবলি।
50-50-50.
না, এটা হচ্ছে ওদের টিমের এফোর্ট, আর এটা হচ্ছে ওদের ইন্ডিভিজুয়াল স্কোর। হয়তো ওই বেস্ট স্পিকার বা কিছু হয়তো একটা থাকবে।
হ্যাঁ তো কিন্তু 150 তে হলো দেন তো
Then 150 হয়েছিল।
No, I think this is for the team. So the first, this is for the team, right? And these are for the individuals.
So total marks will be total marks 150. That individual.
Rebuttal.
Yes.
So start.
Your Lordships, if I have your permission, shall I proceed?
Yes.
Your Lordships, we would firstly like to disregard what we first like to contend on the burden of proof that they have said lies on the prosecution. It does not lie on the prosecution, it lies on them. And even in this instance, if we see, like I had cited before, the evidence that they had given to the High Court as well as the trial court doesn't necessarily prove that that Priya Desai's actions did not cause a breach of security. It merely says that she was pursuing her journalistic integrity. My point is, even if she was pursuing her journalistic integrity, her actions did cause a breach of security. Further, if we look at the MOOT proposition in paragraph 10, line 5, it has been stated that her actions were in the pursuit of journalistic integrity because the state's action had caused potential endangerment of civilian lives. The respondent has time and again contested that whatever we have been providing as evidence is not sufficient enough and we are merely making speculative...
Madam, I'm sorry for the interruption. I don't take it otherwise.
No, absolutely not, my lordship.
Admittedly, the UAPA is a little bit a draconian law since the burden is upon the accused to prove that he is innocent. But does it discharge the prosecution to prove the initial ownership?
Absolutely not, your lordship.
Say, please embark your judgment, embark your argument on that point only.
Your lordships, if we see, we have...
Interested to listen on that point only.
Your Lordships, if we see the evidence,
Please confine your argument with regard to the initial owners upon the prosecution and
Absolutely,
how
Your
they have
Lordship.
discharged the same.
Absolutely, Your Lordship. If we look at the evidence that we had provided at the trial court stage, there were 3 instances of it.
Yes.
There was an official testimony by a high-ranking official, there was a sealed dossier submitted, and there was a testimony by the digital forensic expert providing that there was a surge in encrypted messages amongst insurgent groups. Now, we cannot say that 3 simultaneous instances of rise in hostile entities and insurgent communications has happened in a chain of coincidences when it happened right after the publication of this article. In fact, the dossier that we provided did contain information that was directly referenced in Priya Desai's article as well. Now that they challenge that we provided a sealed dossier, it is because we had communications of hostile entities in it that was also beyond whatever information Priya Desai had divulged. There were other information in it. We, in the concern of keeping the state from further damage, decided to provide a sealed dossier for the same, which if the trial court had deemed to be befit, could have divulged the information to the respondents at the same. It was the discretion of the sessions court to decide not to inform the other information that was provided in the sealed dossier itself. So our contention is that we had provided the evidence. There is a chain in it that 3 instances of rise in insurgent communications was established, and it happened consecutively. There was no gap between them, and it happened right after the publication of the article. So we have concrete reason to doubt that the actions of Priya Desai's publication caused this breach of security in it. That is our establishment through the evidence, which was rightfully accepted by the trial court during the proceedings.
So by this way you have discharged your initial owners.
Yes. Whereas when Priya Desai had done the same, she did not provide...
Give us a second.
Right, sir.
Give us a second. Yes.
Whereas when Priya Desai did the same, her evidences did not in any form provide that she was innocent, that her only claim was, I am pursuing my journalistic integrity, that I have done everything in the interest of journalistic integrity. Speaking of integrity, if we see, it has been stated that Priya Desai is a seasoned journalist. She has been in the pursuit of holding the government accountable in its actions from the very beginning of her career. It's not a new thing. So she has provided articles even before this that had dissent against the government. We have never put any charges against those articles. We have never provided charges against those articles. If there has been dissent, if the government has to have held themselves accountable, we have rightfully done so. But in the present instance, when national security is at stake, we could not withhold providing accusations or charges against her that we found to be relevant in this matter. Secondly, if we see, the press control of India has set out certain norms even in regards to investigative journalism in Article 21 of their norms, which states that even in the pursuit of investigative journalism, we have to keep a reasonable check on sensitive information being divulged on the same.
Counsel, you're here to rebut, right? You're not here to bring out new arguments.
No, absolutely
So
not.
just confine your rebuttals to a rebuttal.
Absolutely not, Your Lordship. I'm only providing this point since there was a question of reasonableness. So such reasonable restriction has been provided even by the press board themselves while writing their articles.
Counsel, when the reasonable restrictions are provided by the Constitution, that is good enough for
Absolutely, Your
us.
Lordship.
So we don't need the Press Council of India's dictates.
Absolutely, Your Lordship, I get it. Further, if we see the 2019 amendments that has occurred in the Unlawful Preventions Act, it also states that any action that promotes terrorism could also be reasonably put forward in charges against it. And we have rightfully taken that amendment into consideration when we have charged Priya Desai for her actions that has caused national security breaches. We have not purposefully used the draconian law that has been claimed by the respondent to be draconian in any pursuit of stifling her journalistic voice. Her journalistic voice has always been given a chance in this state, but in this present matter, in the current action that she has done, which is separate from all her other previous actions of holding the government accountable, the government has decided and found her to be guilty of the charges that have been pushed against her. We believe that her reasoning that she was doing this in pursuit of journalistic integrity might be not as such, that she was rather chasing a notoriety or fame which she eventually got, because this has become a widespread public debate right now. When she has had this long of a career, when she has written such articles before, she must know, she must have kept in mind that there are certain things that you have to put in measures so that you don't put the state into a state of chaos. You have to keep in mind ethical
Counsel,
considerations for the state as
what
well.
are your answers to this claim that they're making that your forces are also committing very, very, very deep-rooted civil liberties and human rights violations?
Absolutely right, Your Lordship. I would like to mention that these are merely alleged claims. They have not proven it beyond reasonable doubt that there actually has been any potential human rights violation
No,
by
a
the
journalist
state.
does not need to prove anything beyond reasonable doubt, Counsel. That's what journalists are there for.
Absolutely, but if we see even in the MOOT proposition, in paragraph 10 itself, line 5 again, where another human rights expert did their own detailed analysis alleging disproportionate use of force which could lead to potential endangerment of civilian lives. That has not occurred yet. It is only a contention that this may have happened. And if she wrote the article in such a manner highlighting only this concern of hers, the state would have taken relevant consideration into it and kept it in mind. But she decided to do so while publishing sensitive information along with it. We believe that this sensitive information could have been bifurcated and
So
the
your
rest of her
problem
concern could
is
have been
not
published.
with, your problem is just with the sensitive information. Your problem is not with the human rights
Absolutely, Your
violation.
Lordship. We are not trying to stifle journalistic liberty here. We are only saying that it should be practiced with reasonable restriction and keeping the state's security in mind as well. Because as a journalist, you are the watchdog. You have the role of a watchdog in a democracy. So not only is it your duty to look after your civilians' interests, but it is also your duty to look after your state's interest in the matter as well. That is all for my liberty. Much obliged, Your
Thank
Lordship.
you. Thank you. ওদের মধ্যে একটা রিবাটাল, একটা সার রিবাটাল।
Much obliged to your lordship. Now, if your lordship permits, the council would like to proceed with some points of rebuttal. The first point is that in their memorial, they have mentioned in page 18 that powers under section 391 of CRPC or section 342 of BNS should be excluded in a restrained manner. So here the power under these to accept new evidences are the discretionary power of the honorable court. So unless
Counsel, in a rebuttal, you only respond to the rebuttals.
Okay.
You don't bring out new arguments.
Okay, Your Lordship. So the fact that the learned counsel stated that the respondent is just doing it for fame or something like that, but the point is that a distinguished human rights expert having conducted an independent investigation presented a detailed analysis that such endangerment of civilian rights were taking place, and the fact that the learned counsel and the petitioner, the government is trying to use national security as a tool to get away from the accountability of harming civilian rights, the right to lives of the people. They are the fundamental rights and they deserve that rights. These are the basic rights that are provided to them within the constitution. And to get away from this accountability, the government is trying to overreach the act, UAPA, and try to hold the respondent accountable for the acts that she didn't even commit. She didn't release such sensitive information. These are just grave accusations by the petitioner. So to do such things to get away from the accountability should not be accepted.
Anything else?
No, Your Lordship.
Thank you so much.
Much obliged, Your Lordship.
You can just take the whole thing. Yeah.
You can take the memorials as well.
they still have a lot of resource and need it that time.
তুমি এদের কিন্তু থাকতে বলতে হবে
All of you are requested to please be seated over here. We will start the valedictory very soon. Okay?
get the certificate.
Arrangement for snacks, so you will get that from 5:30 onwards. So please be seated in the mood. Acha, you will get the snacks in 318. You can definitely go to the washroom, but return back. That's what I mean.
Grazie.